are several parties that are involved in this case, including the plaintiff and the defendant and other several parties. The defendant for this case is Prestasi Tulen, and the second defendant is Tetuan Abdul Aziz and Associates, while the plaintiff for this case is Sunshine Heaven Sendirian Berhad. Along with him is plaintiff witness 1, Teh Suleng, and also plaintiff witness 2, Chen Sak So. First of all, for the material facts of this case, plaintiff witness 1 was informed by plaintiff witness 2 that a piece of land owned by Prestasi Tulen was available for sale. Accordingly, upon knowing this information, plaintiff witness 1 had instructed the plaintiff solicitors to prepare an offer letter to be addressed to Prestasi Tulen. The letter of offer was later handed by the plaintiff witness 2 to Tetuan Abdul Aziz and Associates. On 26 December 2013, Peace solicitor had received a letter from the second defendant stating that they had agreed on the terms and conditions and asking for the 2% earnest money to be paid to them as stakeholders. And on 30th of December 2013, the 2% earnest deposit sum was paid by the plaintiff. On 26 December 2013, Peace solicitor had received a letter from the second defendant stating that they had agreed on the terms and conditions and asking for the 2% earnest money to be paid to them as stakeholders. Later on, the plaintiff solicitors had received a letter from a third party. The party is the solicitor for Prestasi Tulen, and they had claimed that their client had not entered into SPA to sell the land to the plaintiff, and a police report had been lodged regarding this matter. The plaintiff solicitors replied to Owen and Ho that they had been dealing with the second defendant, which the second defendant claimed that he is the solicitor for Prestasi Tulen. Meanwhile, at the same time, on 17 of April 2014, the plaintiff solicitors had written a letter towards the second defendant asking for their comments about the claim made by the defendant's solicitors Owen and Ho. The second defendant then replied the letter saying that there was an internal problem between the shareholders and the director of the company. So on 28 of April 2014, the second defendant wrote to the plaintiff solicitors confirming that they were still holding the earnest money that had been paid. In the end of the story, the 2% earnest sum was paid back towards the plaintiff by the second defendant. But on 27 of May 2014, the plaintiff solicitors had filed a suit against Prestasi Tulen and the second defendant for the claims of breach of duty and misrepresentation.
Assalamualaikum warahmatullahi wabarakatuh. And for the first legal issue of the case is whether legal firm hold a duty of care to purchaser. So, in determining the existence of duty of care, there are two principles, which is the first one is the labor principle, which is in the case of Donahue v. Stevenson. So, the labor principle means one must take reasonable care to avoid acts or omissions that could reasonably be foreseen as likely to injure one's neighbor. So, a neighbor is identified as someone who is close and directly affected by the person's act. So, in the next principle is the Caparo test, which is in the case of Caparo v. Dickman. So, in established duty of care, there are three steps, which is the test of possibility, proximity, and whether it is just and reasonable to impose on duty of care. So for the next legal issue is whether there was sufficient proximity between the two parties. So in determining the proximity in the second, we can use in the context of the Kamarulzaman test, in the second Kamarulzaman test, which is the proximity test. So proximity of relationship derived from Lord and King neighbor principle in the case of Donahue v. Stevenson. The claimant needs to prove the closeness of the relationship by proving physical closeness or closeness of relationship. And lastly, for the last legal issue is whether it would be just and reasonable to impose a duty of care. So it is fair, just and reasonable to impose duty of a given scope on the party for the benefit of the other.
Okay, for the first legal issue, whether the legal firm owned a duty of care to the precation. So, in determining the existence of duty of care, the judge used the Kamarulzaman test in the Kamarulzaman versus Kamarulzaman and Dickman case. So, a tripartite test is used in determining whether a duty of care should be owned. So, this test consists of possibility, proximity, and whether it is just and reasonable to impose a duty of care. So, for the second legal issue mentioned earlier, whether there was sufficient proximity between the two parties, in this legal issue, we need to apply the second test of Kamarulzaman test, which is the proximity test. Okay, why? It is to determine or to prove there must be a legal proximity or legal relationship between the parties from which the law will attribute a duty of care. Okay, and for the last legal issue, whether it will be fair, just, and reasonable to impose duty of care. Okay, as mentioned earlier, it will be fair, just, and reasonable to impose duty of care because it will benefit the individual in the future. However, based on the evidence in the case, the judge decided that it is not just and reasonable to impose duty of care on the second defendant. Because based on the evidence in the case, there are no special circumstances giving rise to the duty of care based on the allied finance principle, thus making it not fair, just, and reasonable to impose duty of care.
For the decision of the court, in the light of the above, we are constrained to hold that there was a misdirection on the law and on the facts by the learned judge. We therefore set aside the decision of the learned judge, holding that the second defendant was under a duty of care to the plaintiff. Since we ruled that the second defendant owed no duty of care to the plaintiff, it must follow that the plaintiff's claim shall be dismissed. In consequence, the appeal is allowed. The decision of the High Court is set aside, and we award cost hence and below to the second defendant.
So for the conclusions, the main discussion about these cases is about the professional, advocate and solicitors, whether they have a duty of care to their own client. So normally, a professional person, they already have responsibilities to their own client. So they need to follow a certain standard of procedure in order to entertain their client. The principle is not only applying to the advocate and solicitor, it's applied in every field of professional occupations. But in these particular cases, the professional need to foresee about what will happen if they neglect the standard of procedure, whether intentionally or unintentionally. For these particular cases, it's already been explained by my friends before this, that the advocate and solicitor does not liable and does not have any duty of care to their client, because the negligence and misinterpretation is actually come from their own ground. That's all from us. Thank you very much.